of all, I'm sure most of you are aware that the UK left the EU January 2020. And within the EU withdrawal agreement, there were various protections that were given to the EU nationals. Part of the protection is for them to continue to live here and also to bring their families under the family reunion laws and the policies. So although the UK has left the EU, yet the EU nationals and their family members here, and even those who are not here, which are the family members who are not here, are protected if certain basic factors or requirements are met. The first requirement is that you are an EU national, okay, or you're a family member of an EU national. The second requirement is that by 11 p.m. on the 31st of December, you have been here. Now, I used to say you were here. You physically don't have to be here. So let's say if you were here in 2019, but you left 2020 January, and then you came back in 2021 February. Because you came here before the 31st of December 2020, you are still protected. What is the protection? The protection is that you can continue to live here. But you have one more act and task to perform, and the task is that between now and June, if you haven't registered on the 𝘂𝑚𝑠𝑠, which is the EU Settlement Scheme platform, you need to put in an application. It's a fairly straightforward application, but again, if you can't speak or read English, then somebody ought to help you. What you need to go online is, if you've got a biometric card, you have to use the app on your phone to read the card, because the card has got an embedded chip which has all your details in there. Once you've registered on the system, you will get an email prompt. You also get a text message, and the email eventually will confirm that you have been granted either pre-settled status, which is a limited leave to remain, or settled status, which is indefinite leave to remain. Whilst you are here, you can bring your family members. Okay. There are two categories of family members that you can continue to bring even after June. These are family members who are non-dependent, so that will be your children and grandchildren under 21, and family members who are dependent, which will be your parents, your grandparents, your children and grandchildren who are over 21. If a child or grandchild is over 21, they ought to be dependent on you before you can apply to bring them. Your parents are always, and your grandparents are always considered as dependent family members. So again, if you want to bring your mom now, they're not going to ask you to show dependency, because you can still make the application either under the EEA or under the EU. But from June, two extra requirements will be needed. One, that you have done the 𝘂𝑚𝑠𝑠, and two, that she's dependent on you. The other right which is protected is your right to claim state benefit. So although some of you will be aware that those people who have limited leave to remain are usually not allowed to claim benefit, the Court of Appeal has said that EU nationals and their family members who have limited leave to remain, and again remember, their limited leave to remain does not say no recourse to public funds. Okay. So the habitual residence test has been amended because they restricted it to prevent those people from claiming benefit. Because of the Court of Appeal decision, you can still claim it. You can apply for housing. You can also apply for student finance or student loan, and you're entitled to home student fees. Finally, if you are an EU national, you were here before or by the 31st of December, and you contract a new family. So how do you contract a new family? Through marriage, usually. So your wife and your wife's children, they will come under the British immigration rules. Okay. So although you don't have indefinite leave to remain, because prior to January this year, it was only people who were settled, asylum holders and refugee people, or people with humanitarian protection, who could bring people here. Those who had limited leave could not. But again, the law has been amended, which means that EU nationals who have limited leave to remain can continue to bring their family members ad infinitum, which means that as long as the law allows. You have to meet the English language and the financial maintenance test, and also accommodation. But again, if your wife or your husband was your wife or your husband by the 31st of December, this will not apply. So those EU nationals who are Ghanaians and are looking to marry Ghanaians or have married Ghanaians but are yet to bring them, because our marriage is usually done formally or informally in our homes and houses, the registration can be made after December 2020, which means that if you married 𝗪𝗏 or 𝗏𝗀𝗃 in 2020 June, but because you want to bring her now to the UK, let's say you want to bring her in July or August, you can still bring her under the current dispensation because she became your family member before December 31st.
Right.